On this episode of Good Law, Bad Law, we take a look at the Supreme Court's Heller decision of 10 years ago, the landmark ruling written by Justice Scalia, which established for the first time in our country's history what many thought for a long time it was all about, an individual right to bear arms. But also importantly, the fact that there can be reasonable limitations on that right. My guest is Joseph Blocher, a Duke University Law School professor who was involved in the Heller decision when he was a lawyer and has now written extensively on the Second Amendment, what it means and what it doesn't mean, and why and how those who continue to be so partisan and so passionate about the gun issue actually can get together and have a reasonable conversation about gun rights, gun regulations, gun limitations, all found in the pages and the words of that Heller decision. Very interesting and important and timely conversation about the Second Amendment. Stay tuned. Welcome back to Good Law, Bad Law. On this episode, we're going to talk about what arguably is the most controversial, the most partisan piece in the Constitution, the Second Amendment, and the issue of guns. And to help me through this is a real expert on the subject, professor of law at Duke University, Joseph Blocher. So Joseph, thanks so much for being on the program.
Thank you so much for having me.
I want to get to the special place that you have in the history of this really huge and important Supreme Court decision that we're recognizing 10 years ago, the Heller decision, Justice Scalia's Heller decision. And I also want to get to your book on the subject of the Second Amendment. But before we dive into all that, give us a little bit of background on yourself and perhaps take us up to the point that you become directly involved in this very important Supreme Court case that we're going to talk about.
I'd be happy to. In fact, almost 11 years ago to this day, I was starting as a young associate at O'Melveny & Myers, which is a law firm in Washington, D.C., working primarily with a partner at that firm in Walter Dellinger, who's a former Solicitor General.
Right.
Walter asked me one day what my views were on the Second Amendment. And I had to answer honestly that I don't have very well-informed views on the Second Amendment as a matter of constitutional text and history because, like most constitutional law, students at the time, I hadn't been taught it. It was not a part of the curriculum in most constitutional case books or anything. And he said,
and there wasn't that much to teach, right?
It would have been a quick thing. You could have taught, just a couple, really a handful of Supreme Court cases even glancingly mentioned it. And until 2000, there wasn't a single federal case in the history of the United States striking down a law on Second Amendment grounds. So it was really just kind of a moribund area. I mean, it was just not a lot happening. As a matter of law. Again, politically, of course, as people were invoking the Second Amendment, they were arguing about it, but there weren't really major cases. But as it turned out, there was a major case working its way up to the Supreme Court that year. And I started working with Walter on it. The case was then called Parker. And then for a variety of reasons having to do with standing, Dick Heller became the lead plaintiff. And the case turned into something called District of Columbia v. Heller, which was eventually resolved by the Supreme Court in June of 2008. So my role was part of a great and large litigation team helping to write the briefs on the District of Columbia side, defending the constitutionality of the district's gun law. So that's how I got interested in it, really, was in practice. And now I've spent almost every day since then thinking about it or writing about it.
And the gun law in the District of Columbia that was being challenged at that time was a complete ban on handguns. Is that right?
Effectively, yeah. There were a few minor exceptions, but it's not I think inaccurate to think about it as a handgun ban. Washington had put it in place in the mid 70s. Really, Washington and Chicago were the only two major cities that had those kinds of laws, and they were, like most places, were struggling with how to respond to problems of urban crime. And in DC's situation in particular, that was complicated by the fact that Virginia, right next door, has a much different set of gun laws. There's all these really hard questions about what it takes to make that kind of a law work. The other part that was challenged, I should mention, and the handgun ban was the part that was central, but also Dick Heller and his legal team challenged a restriction that required guns to be locked and disassembled when not in use. So, you couldn't have your gun loaded on your nightstand, and they challenged that as well.
Okay, so that's the case, and we're going to talk. I want to talk about the case, and also cover something about the book that you've just come out with, along with your co-author Daryl Miller, called "The Positive Second Amendment: Rights, Regulation, and the Future of Heller." And I know that's been a focus of yours over the 10 years since this really landmark, groundbreaking Second Amendment defining Supreme Court case, the Heller case. Namely, what is the scope of this? What is the significance of this decision? But I want to start with a quote from your book, which I am reading and enjoying, by the way, and I recommend to people. It's really the history of the Second Amendment and guns and gun rights and gun control, going all the way back to ancient England, really. But this quote really struck me, where you say, and this is in the introduction, the extremists are wrong about the Second Amendment. They're wrong about what the other side believes, and they are often just as wrong about what they believe. They're wrong about what they disagree about, and they are wrong about what they agree about. They are wrong to conflate support for the Second Amendment with opposition to gun regulation, wrong to equate support for gun regulation with rejection of the Second Amendment, and wrong to treat agreement with Heller as a litmus test for supporting the Second Amendment. Most of all, they are wrong to believe these things with such certainty. So, I mean, to me, that's such a great launching point for our discussion, because you're really saying everybody's got it wrong, from the NRA supporting gun rights folks on one side and those who want to see more active legislation to impose limits on gun use and access to guns and things of that nature, that everybody's wrong about this incredibly important Supreme Court decision, the Heller case. So I think we have to start by explaining exactly what it is that it did and what it stands for.
I think that I'm happy to do that. Oh, I'm really happy to do it. And I should say that really who I'm speaking to there is not just everyone. It's everyone whose voices you hear. I actually think that more people are in the middle on this issue than you would imagine, based on this kind of screeching, polarizing political debate you see sort of play out publicly. I mean, the extreme voices take all the oxygen out of the room. Mm-hmm. But one of the themes that we're trying to get across is that actually there's a big middle here where most Americans already are, which is they recognize an individual right to keep and bear arms, and they recognize that it's subject to regulation. So we're doing it in kind of a shouty way ourselves, I guess. But what we're trying to do is get that part of the American public, of the constitutional tradition, of the existing doctrine, kind of heard over this kind of, partisan, polarizing, screaming kind of debate. It's not that everyone's wrong. It's just that the really loud voices are wrong, and they're drowning out the sort of, the people who I think, frankly, are in the middle. And, to your question about, well, how does Heller sort of fit in there? There's sort of two, I would say maybe we could start by saying there's sort of two major things to take away from Heller. One is a thing for which it's best known. The central question in Heller was, is the Second Amendment limited to basically people and arms and activities that have to do with the organized militia? So you hear people often say, well-regulated militia being necessary to the security of a free state. That means this is about the state militia. And then the other view was, this is sort of the competing view that between the two of which the court had to decide in Heller, is that no, it's not about organized militia. It's really a right for everyone, whether or not they are in any way connected with the organized militia. That's sometimes called the individual rights view. Mm-hmm. And what Heller did, and this is what I think makes it significant and potentially controversial, was the justices ruled 5-4 in favor of that individual rights view. So that's like the main central, people talk about Heller, that's like the main takeaway point I think that they want to get to. But there's the other part of it, and this is the part that I think sometimes gets lost, both by people who like Heller and by people who are criticizing it. is that the court, and Justice Scalia is writing the majority opinion here, really goes out of its way to emphasize, look, this right, like all constitutional rights, is subject to regulation. Yeah. And the court goes on to list some forms, and we can certainly talk about those, but it's like holding both of those things in one's mind is really what I think carves out that space in the middle.
Well, let's take those separately. First of all, the individual rights holding of Heller, which is, first of all, it's fascinating that it takes until 2008 for the Supreme Court to declare that. Here is the, not some remote, distant, obscure part of the Constitution. It's the Second Amendment. And yet it took until 2008 for the Supreme Court to clear up this question and to really give the authority and weight of the Supreme Court's ruling to those who for a long time had been using the phrase "a right to bear arms." So how did it take the Supreme Court as long as it did to get to the point where it would recognize that that's the core of the Second Amendment here?
It's a really hard question, and it's one that, in some respects, I'm not well positioned to answer, just because by the time I became conscious of it, those two views were both prominent, both the militia-based view and the sort of individual private purposes view. But when you read the history, I would say it is striking just how much the militia-based view dominated. I mean, what I said earlier is I just think so amazing that for more than 200 years, there's not a single federal case anywhere in the country that strikes down a law on Second Amendment grounds. There's one district court decision in 2001 that quickly got overturned. It's like the Third Amendment, against quartering troops in the home. There's just nothing happening as a matter of doctrine. Now, sometimes it does take the court a while to get around to, really developing the jurisprudence of an amendment. In fact, Justice Scalia pointed this out, that it took, really until the early 1900s for the First Amendment even to become, what we think of as today, like an enforceable, important right to free speech. So I don't want to read too much into it, but I do think it's true, at least within doctrine and within the legal academy, that the militia view just overwhelmingly dominated. So there wasn't even really like a confusion to clear up from most people's minds. And this wasn't a partisan thing. This was left, right, and center.
And it's not like there weren't limits on gun use that were on the books that could have provided a basis for challenge long before DC's handgun ban, if we'll just call it that for shorthand. So, there was a more organized effort to focus on litigation in the courts by the NRA and others in the gun rights movement. I wonder if that, provided some impetus through the courts to have this become something the court had to resolve.
Oh, I think you're absolutely right there. I actually think there's two really important things in what you said, just to emphasize. One is, you're certainly right, and this is something people, I think, also underestimate, to say that there was a lot, more than people realize, a lot of gun regulation on the books going back to the founding. Like, this is not a new thing. The Brady Center didn't invent gun regulation. That's something that we've had on the books from the, as you mentioned in the introduction, going back before this was a United States. So there were ample opportunities. Now, some of that got resolved under state constitutional law because the states have their own constitutions, their own bills of rights, and many of them already recognized the individual right. But it's true, as a matter of Second Amendment doctrine, there's just not a lot happening. And I think there is something to the story, certainly, that you could pinpoint the beginning of this at different times, but really with the sort of rise of the law and order frame, the NRA's pivot in the late 70s from being mostly an organization devoted to recreational gun use and gun safety to being a group that now lists protection of constitutional rights as among its top priority, that you just had much more institutional force and energy, and also just more, how to put this, sort of fear of others, fear of crime, sort of driving the gun market. For a very long time, recreational use of guns was the number one reason for gun ownership. In the last few years, it slipped over to self-defense. Yeah. And so that, I think, kind of tracks and maybe explains a little bit the changing popular view, let's say, about what the Second Amendment itself is for.
So the main part of Heller then recognizes an individual right to bear arms or to have and carry and use guns, whether for self-defense or recreational use or any other lawful purpose. But there is this section of Justice Scalia's opinion. We've actually talked about this on this podcast before when we were reflecting on the legacy of Justice Kennedy. And I think it was actually someone who's quoted in your book, Professor Joyce Malcolm, who we had on looking back at the legacy of Justice Kennedy. And we talked about that passage in the Heller case where it is recognized that the Second Amendment is not an absolute right, and that there are limitations on that right. And that was something she pointed out that was very important to Justice Kennedy to get him to sign on to the 5 votes, to become one of the 5 votes to be in that majority along with Scalia. That really is the other very important part of the Second Amendment and this decision that I think you would agree, right? A lot of people don't even realize is core to that decision.
I 100% agree. And, it's hard to know what was the price of Kennedy's vote or the Chief Justice's vote for that matter. But I think it's certainly often said, and maybe exactly right, that this particular paragraph, and I can almost quote this from memory, but as many times as I've had to read it or cite it, but the court says, there's nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions on the commercial sale of arms. I mean, that's just one sentence. And there's a couple other places in there where the court also refers to bans on dangerous and unusual weapons and bans on concealed carrying, for example. And there's not a lot of explanation or discussion of that in the court's opinion.
Right,
people
it's just
criticized
stated.
it for this. It's just stated. I think this is one reason people assume that it was there, to win over the 5th vote, potentially 4th and 5th vote, and not. It's not given the same sort of depth of historical analysis, let's say, that other parts of the opinion are. But the court says, look, these are okay. And that's how it's been read. That's how lower courts have interpreted it. And that paragraph is, it leaves a potentially big regulatory space. It happens to match up with, what most gun laws on the books today tend to reach: dangerous, unusual weapons, particular classes of persons like felons, the mentally ill. And it's a hugely important part. I completely agree with you. Hugely important part of Heller. It's one of the reasons that we titled our book, The Positive Second Amendment, Rights, Regulation, and the Future of Heller, because they're both part of the Second Amendment's tradition. They always have been.
So maybe since we've now gotten both of the main components of Heller out, maybe you could explain this. Also a quote from your new book, where you say, to oversimplify a bit, and you're really talking about just how partisan this issue is. And we all know that unfortunately there have been far too many school shootings and other mass shootings, and the debate kind of reignites with great passion on all sides, understandably, when these things happen. But you say, to oversimplify a bit, liberals must take the law of the Second Amendment seriously. Conservatives must take the Second Amendment seriously as law. So what do you mean by that?
Yeah, it's a great question. And this is going back a little bit to the sort of earlier passage in the book where we're sort of talking to the extremes, the people who are way on one end, partisan or otherwise, on this issue. And I would say that to begin with, what we call liberals there wouldn't have to necessarily be political liberals, but I think that there are people who really don't appreciate, understand, take seriously the sort of good faith of the vast majority of American gun owners who themselves, are law-abiding, who wish nothing but the best, who would, if they could, figure out ways to, reduce gun violence. Certainly not in favor of, rampant gun misuse. I mean, there's a tendency sometimes, maybe among some, to just look down on that. And I think that's too bad. For a very long time, and this is especially true in places like the academy, people just ignore the Second Amendment and don't really pay attention to it. It doesn't get the same attention that the First Amendment or the 14th or others do, where for some people it is, sort of a core part of their identity and something that they care very much about. And I think that's really, just too bad that liberals would do that. Some liberals might do that, and also counterproductive, because as it happens, 75% of Americans agreed with the result in Heller. There are that individual rights view has taken root, whether or not it was historically, part of the tradition. It certainly is now. And I don't want to overstate this. I actually think, flipping to the other side a little bit, there's a tendency to impute bad faith to, all liberals are all gun grabbers, and there's always this fear that Obama was coming to take everybody's guns.
Right.
And Obama did nothing in his 8 years other than really loosen gun laws. We had no major federal legislation come through. Both he and John McCain, they were campaigning that summer of 2008 when Heller came down. They both came out and celebrated the result. So I don't want to overstate this, that I think people on the left look down on the Second Amendment. Flipping to the other side. Oh, sorry. Was that a question? I didn't mean to.
Well, no, I was going to say that there is a tendency, but maybe this is a function of our politics today, and we've been in this state of our politics for a while now, where you have to demonize the person you perceive to be on the other side. You can't have a reasonable discussion in that middle ground, or even look to find a middle ground. It's if you're pro-gun, no regulation is acceptable, and if you're for regulations, it means you're coming for my guns. And if you're trying to advocate for sensible gun restrictions, you have to do that by saying the people supporting guns are all about holing up in some remote area of the country waiting to take down the government. There's no
It's prone to the gun debate in particular, and it's certainly not the only example, unfortunately, but it's really prone to this kind of absolutism. So that on one side, the one I was just describing, there are some who would sort of demonize the Second Amendment, and again, unnecessarily, people who call for it to be repealed or for Heller to be overturned. It's not the Heller decision and the Second Amendment are not the obstacles to gun regulation in this country. Those are political obstacles. And on the other side, if one side sees the Second Amendment as a demon, the other sees it as this sort of perfect, invincible champion, which strikes down any kind of gun regulation. You sometimes hear people say things like, quoting from the language of the Second Amendment, "What part of shall not be infringed do you not understand?"
Right.
That's not right. As a matter of law, that's just not right. So one of the things,
pun intended, it's like the silver bullet against anyone who stands up for any regulation.
I hope you don't mind if I use that pun in the second edition of the book, because that's totally right. The silver bullet is exactly how it's treated. I mean, I guess what we're trying to say is, you'll often hear people say things like, "I oppose gun regulation because I support the Second Amendment," or vice versa, and that is just a false choice. That is, it's a lazy way out. You can make that decision. You can be an absolutist. But you can't drag the Constitution into it. The doctrine does not demand that choice. And Heller itself doesn't make that choice, as we were just saying. It recognizes both the right and the regulation. So if we can do anything to minimize that false dichotomy, we would be thrilled.
So then it does really become, as you say, a political issue, not so much a constitutional issue. For instance, and you talk about the subject of background checks or expanding of background checks, which comes up often, and for some is a non-starter, and for others is a no-brainer. But I guess what you would say is you can talk about whether expanding background checks is reasonable. You can talk about whether it's workable. You can talk about other aspects of that idea, but from a constitutional standpoint, there's nothing in Heller that would make a federal background check law unconstitutional or violative of the Second Amendment, right?
I think that's exactly right. A properly written expansion of the current background check system would be perfectly constitutional under Heller, and I don't think it would even be a close case.
Mm-hmm.
But exactly as you say, there is this sort of division of opinion on that. Now, it's not an even split. There are some gun issues, gun regulations, proposed gun regulations, where Americans are 50-50 or 60-40. Assault weapons bans are in that category.
Mm-hmm.
That's not an overwhelming majority. But expansion of background checks is one which, and we tell the story a little bit in the book, where there's just an overwhelming popular support for that. And that's not partisan. That's one of the few things where you find the majority of gun owners, the majority of NRA members are in support. And overall, depends on the poll, depends on when it's taken, you see support anywhere from 60 up to 90%. I mean, just imagine anything that 90% of Americans agree on is just incredible, as far as legislation goes. But when there was a proposal to expand the background check system, this is the Mencken-Toomey Amendment in the wake of the Sandy Hook massacre, it didn't even get out of the Senate. And I just thought that was fascinating. Like, how do you not get this one through? Background checks are what keep guns away from people who've been adjudicated mentally ill, who have disqualifying felonies. It's certainly a system that could use some help, but there have been something like 2 or 3 million people who've been caught by the background check system that has denied access to a gun that they probably shouldn't have had. That strikes me as like something that, let's see if we can, fine tune this and make it even better.
Right.
So what we looked into was, well, what's the most common reason people gave who opposed it, of that whatever percentile that is? And the most common reason invoked, Gallup did a poll on this, is that expanded background checks would violate the Second Amendment, or the right to own guns, I think is how it's phrased in the poll. And that is the kind of thing we would just love to be able to clear up, because again, as a matter of law, it's just false. That's kind of this misunderstanding of constitutional law infecting the political debate. So if you want to be against background checks because you don't trust the government to do them or whatever, that's fine. But you can't short circuit that conversation by just trying to play the Second Amendment as a trump card.
Or if you want to be just out in the open and honest about being entirely partisan about it and say, no, I want to be 100% with the NRA and with gun owners, and I don't accept any limitation on guns. You could make that, I guess, as a political position. But what you would say is you can't make that as a constitutional position. You can't say that the Second Amendment, that I stand with the Second Amendment and oppose, therefore, any regulation against guns.
Yeah, it gets used as this kind of like political shibboleth or some kind like a banner, instead of 27 words in our Constitution which have legal meaning and have, in the last 10 years alone, 1,000 now cases interpreting and sort of fleshing out what it means and how it applies in practice. And if you really care about the Constitution, then you care about what it says and you care about what the courts say it says. And there's not a lot of room even to argue from within that frame that, for example, background checks would be unconstitutional. And so, that's what we want. This is, I guess, going back to what we were sort of talking about earlier about taking the Second Amendment seriously as law. Right? If you want to just invoke, I'm a gun rights absolutist up and down, then fine. I can't reach that with a legal argument. But again, you can't make the Constitution a foundation for that. And I would say, I've talked to lots of people who describe themselves as gun rights absolutists, but usually when you ask some questions about, well, so would you say that somebody who's been convicted of a crime of terrorism should have an access to an automatic weapon? They'll say no, of course not. It's like, okay, well then let's talk about how far the lines go. And you might not agree, but at least you can kind of see, hopefully, kind of each other's perspective.
Yeah, I like to, the example I go to often when I get involved in these debates is on the types of weapons. I say, well, how would you feel about somebody owning a rocket launcher or a howitzer or a cannon? I mean, we don't see people. Now, I think there probably are people who think, hey, I should be able to buy a cannon if I want one. But I think most reasonable people would say, yeah, that's not something the Second Amendment would protect. So, and we know there are these parallels with the First Amendment. I mean, I consider myself to be more on the absolutist end of things when it comes to the First Amendment. But as a matter of constitutional interpretation, obviously, we know there are limits to free speech. There's nothing absolute about it as far as the Constitution goes.
I completely agree on both of those things. I mean, on the question of, sort of what constitutes an arm, because that's the phrase obviously the Second Amendment uses, that's a hard thing to answer. I mean, especially in a world where, weaponry is much more complex and much more can be much more devastating than what existed in the late 1700s. Now, that doesn't mean, and I think this would not be a good argument for a pro-regulation person, that doesn't mean that only muskets are protected or anything like that, any more than, email isn't protected by the First Amendment because the framers didn't know about it. Like, that's not a good argument.
Right.
But it is certainly true that there are questions that the Second Amendment has to confront about what's in and what's out. And the speech example that you raise, I think, is a perfect analogy. There are certain kinds of things that, although they involve expression and they can involve a lot of words, just don't even ring the bell as far as the First Amendment is concerned. Libel, child pornography, securities fraud.
Right.
Like you, I consider myself pretty far on the spectrum of being a free speech absolutist. I'm an ACLU regional board member. I'm well over there, but that is historically, doctrinally the case. So it doesn't mean this is not carving out the Second Amendment for some kind of, second-class treatment. That's just how constitutional rights work.
Well, let's take a look, Joseph, at how Heller has worked, and I know you've also looked at this as part of your academic work, reflecting back on the 10 years since Justice Scalia's Heller opinion, and how this scheme, where you recognize an individual right to bear arms, put aside what arms actually means, because that can be debated too. But you have an individual right to have a gun, but not without reasonable limitations. And so how has this played out over the last 10 years since Heller, as cases involving gun limitations and gun rights have worked their way through the federal courts?
It's a great question and requires there's lots of different ways to answer, sort of different levels of detail. So let me start with a very, very broad sort of, here's kind of overall what most courts are doing, at least most federal courts of appeals are doing after Heller. It's basically, they're applying what's often referred to as a two-part test, or the two-part test. Mm-hmm. And it's kind of easy to conceptualize, I think, in like two dimensions. The first is the question of scope. Like a threshold, is this case even within the Second Amendment or not? And there's a lot of things that just, like we were saying about libel and child pornography and securities fraud, just don't even get in the door as Second Amendment claims. So, weapons of mass destruction, following the language of Heller, felons, people who've been adjudicated mentally ill, they just don't fall within the scope of the right. So they can be banned, consistent with the Second Amendment. That's sort of the first question. There's really hard and difficult, I think, issues about, well, how do you draw those lines? Is it based on history? And we can talk about those. But even if you get into the Second Amendment sort of tent, there are still hard questions about, well, how much protection are you going to get? Because, again, as with other constitutional rights, there are varying levels of doctrinal protection, levels of scrutiny, we might say, in other areas of constitutional law. So in free speech, political speech is on the top of the mountain, commercial speech a little bit more down in the valley. In Second Amendment cases, the same thing happens. Self-protection in your home, the court tells us in Heller, that's where the Second Amendment rights are sort of most acute, the court says. So that's kind of the top of the mountain.
The strongest protection. The strongest protection
exactly.
Under the Second Amendment, if you're in your home and a gun is for self-defense. And that makes sense.
That's exactly it, which I think is what most people think. The court in a later decision described that as the core of the Second Amendment. And I think that resonates with most people. If it's about self-defense, surely, your self-defense rights are at their apex in the home. They're strongest there. But then what do you want to carry your gun into public? The need for self-defense might arise in a parking lot or on your way to work. How does it sort of track when you get outside the door? And this is the area where I think there's still a lot of unanswered questions about, just how strong does the level of protection get? So that's kind of the map as I think about it. It's kind of like I think about it like a topographical map of an island, basically. It's like you're on the island, that's step one. Then you got to figure out kind of how high up are you, depending on what's the right that's being asserted.
But one thing as you've looked, and I know, and I read a write-up you did in Vox looking at federal cases all the federal cases involving or invoking the Second Amendment since Heller. I know one thing that you found in looking at those decisions that really underscores what we've been talking about so far, but the idea that there isn't an absolute right created by Heller, and that we understand there can be reasonable limitations, is in those cases where where somebody has invoked the Second Amendment and argued that it is absolute, argued that the gun rights protections in the Second Amendment are absolute under Heller. Those have failed almost to a one over this 10-year period, right?
That's exactly right. Actually, the underlying project is one I did with my co-author Eric Rubin of NYU Law School and the Brennan Center, and we, as you say, read or had research assistants read every single available post-Heller Second Amendment case from 2008 until February of 2016, which gave us a lot of data. And we asked 100 questions really of every case. So we could really dig down on like, why are these cases losing? And anyway, one of the big takeaways is just as you say, these cases are overwhelmingly percentage-wise losers. Something like 90% plus of Second Amendment claims fail. And so the natural next question is, well, why? And some people have asserted, well, that's because courts are biased against the Second Amendment. They're treating it as a second-class right. It doesn't get the same respect as the First or the 14th, let's say. And what we found is that's not.
Example. Joseph, give us when you say Second Amendment claims and they're failing at these rates. Give us an example of what that claim looks like so we understand that.
Sure. So, there's lots of different ways a person might raise a Second Amendment, what we call a Second Amendment claim or Second Amendment challenge. So here's one. This actually describes a quarter of our entire data set. There's a federal law that prohibits people who've been convicted of a felony from possessing a gun. Right. So if you've been convicted of a felony, then you cannot have a gun under federal law. And that includes lots of people, including, as some have pointed out, Martha Stewart, who might not seem that scary, but that's what the law is. Now, a lot of those people who've been convicted under that law for, let's say, possessing a gun they weren't allowed to, have argued this violates my Second Amendment right. You can't keep a gun away from me. I have an interest in self-defense and so on and so forth. And those claims are almost universally losers because, as the Supreme Court said, again, this is just quoting from Heller, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons. I mean, that's right there. That's pretty much on point. Yeah. So those claims, again, overwhelmingly fail. And that's what we would consider a Second Amendment claim or challenge. It's an argument that the Constitution doesn't allow you to keep this gun out of my hands or for me to carry this gun in this particular place. And a lot of the failure rate, it can be attributed to those kinds of, frankly, weak, bad claims, bad arguments. Now, a criminal defendant has, incentive to throw out as many arguments as possible, within some reason. So it's not surprising that, felon would make that argument and 20 others. But the fact that it's failing doesn't really tell us anything about whether the Second Amendment is being under-enforced or disrespected or anything like that.
So where then do you see what types of Second Amendment claims from the analysis that you did do have a better chance of success? Where is the real tension then in the law as courts are dealing with it over the years since the Heller decision?
I think that the area where we see the most sort of methodological and substantive division is on restrictions on public carry. So what these laws are, and they differ in different places, they look different, but in some areas of the country, not all, but in some areas of the country, in fact, actually I should say not many areas of the country, you have to do something like maybe show good cause in order to get a permit to carry your gun in public. And what that good cause means varies from place to place. It might mean you have to show you live in a high crime area, or it might mean even more than that. People often challenge those laws saying, look, the Second Amendment is, you hear this line often, the Second Amendment is the only license I need. I don't need to go, ask some government bureaucrat to give me a license. To which the response usually is, well, all that's being asked here is that you basically demonstrate you have some, connection to the self-defense interest that underlies the right. Anyway, courts have divided a little bit on the constitutionality of good cause restrictions. The vast majority of them have been upheld. The D.C. Circuit, in a case, I guess it was decided maybe almost 2 years ago now, went the other way and struck down the district's good cause restriction, good cause requirement, which was maybe a little more stringent than most. I think that's where we see not only the most division, but sort of the maybe greatest likelihood of another grant of review from the Supreme Court, because you do have a little bit of a circuit split there.
I was going to say, could you see regional differences in this? I mean, Texas is going to look at the right to carry very differently for a whole variety of reasons than Massachusetts or New York or Illinois would, I would think.
I think that's 100% right. And I should say, I've written on this separately, actually, an article called Firearm Localism in the Yale Law Journal, I think from 2013, made the argument that that has always been the tradition of gun regulation in the United States, is to do things differently in different places, and particularly to do things differently in cities as opposed to in rural areas, because the sort of phenomena of guns is just different in different places. In cities is really where the costs are concentrated and where the benefits are much fewer, because you don't have access to hunting, recreational shooting, and that kind of thing if you're in the district. If you're in New York, if you're in Philadelphia, right? Those are not things that are available to you. On the other hand, you are much more likely to be a victim of a shooting in a city than you are in a rural area. So it wouldn't at all be surprising to have more stringent gun regulations, and frankly, a Second Amendment doctrine that recognizes that. One of the examples I always give here is the example of the sort of famous cow towns, the Wild West towns, sort of Dodge City and Tombstone, Arizona, had like gun regulations that would make the Brady Center blush. I mean, that was you were required to check your gun when you entered town, which again, not even the district really goes that far. So we have that tradition. To the degree to which it'll be still vibrant is a little harder to say.
Well, and of course the challenge we face going forward on this, and you do talk a lot about this, and we've mentioned it, is just the partisan nature of this particular debate. And what I really like about what you've set out in the book, and again, we'll put a link up so people can know how to get a copy of it, to learn a whole lot more about this. But there really is a playing field here that everybody can get on and have a reasonable conversation about gun restrictions. But as long as we're, in this shouting at each other a place, we're not on that playing field. We're just standing on the sides shouting at each other. But if you look at the Second Amendment, you understand what the Supreme Court did in Heller. There really is a way to have a reasonable, rational conversation and balance these things, and everybody can feel good about it. I hope that happens.
And they can. Fingers crossed. And I hope that when people do that, if they do that, and I hope they will, they'll feel that they're not alone. They're there with the Second Amendment. That's where the Constitution is. It's in the middle on this issue. I mean, I don't like thinking about just in terms of, one side of the spectrum to the other, but the law, the history, the tradition of the Second Amendment, including as reflected in Heller, is there in the middle. And in that, it recognizes a fundamental individual right to keep and bear arms for private purposes like self-defense. We've got that, definitely. And courts strike down laws that, go too far in restricting the ability to exercise that right. And also, we have access to regulation, and that's part of the constitutional tradition as well.
Well, and it's fascinating to me that this really groundbreaking decision comes out of the Supreme Court at a time when so many people refer to the Supreme Court as so split and so partisan and so political. But this isn't really about that. Even from this court, you get this balance, and it really isn't about left, right, liberal, conservative, or anything. It's really a balanced approach, and there it is. It's ready to be taken up.
I would say that the holding of Heller, at least encompassing both that right and the regulation, is something that is consistent with the party platforms of the Republican Party, of the Democratic Party, and with, I would venture to say, the majority of Americans. I mentioned earlier, three-quarters of Americans supported the result in Heller when it came down on the individual rights point. And also mentioned, and just to reemphasize, an overwhelming majority of Americans apparently support background checks. That means there's overlap of the people who believe in the right and believe in regulation, and lo and behold, that's where the Second Amendment is. So you might not feel like you're with the NRA, and you might not feel like you're with the Brady Center or groups on the other side, but you might have the Constitution with you.
Well, Joseph Blocher, constitutional law professor at Duke University Law School, and the author of the recently released book, The Positive Second Amendment. Great conversation about the Second Amendment, where we've been and where we are today. Thank you so much for being on the program. I really appreciate it.
Thank you so much for having me.